Hello and welcome to the last in the first part of our series of Royal Institute of Philosophy London Lectures. Called London Lectures, but of course now nobody's in London actually giving them at all. They're entirely globalised online. Our theme this year is a Philosopher's Manifesto. We've been inviting philosophers from all parts of the world, different traditions in philosophy, to offer their own view of what a proposal or a policy that they would recommend to bring about an important change in the world and to give the philosophical case for it. So we're really trying to show here that philosophy has something important to contribute to political and public life. And there'll be an opportunity after the talk for you to ask questions. You just put them into the chat box. 2 requests about the questions. First of all, try to keep them under 200 characters. That means we can display them on screen. And secondly, trying to make them as clear as possible. Don't sort of refer to obscure papers or name drop or theory drop or concept drop. Put it in such a way that anyone can understand it, no matter what their background might be. Today's talk is an extremely interesting and important one. It's been, in the last few years, we've seen quite a lot of civil disobedience and maybe what might also be called uncivil disobedience. How does the state deal with that? And are there appropriate ways of doing it? And what Joseph Chan and Brian Wong are proposing is a new way of dealing with such transgressions. Joseph is Professor in Department of Philosophy and Public Administration at the University of Hong Kong. And his recent book is Confucian Perfectionism, a Political Philosophy for Modern Times. Brian Wong, his collaborator, is a Rhodes Scholar at Balliol College in Oxford. And their research interests primarily constitute rectifying historical and tackling structural injustices under non-ideal circumstances. The talk's very, very clear. For people who are sort of newer to philosophy, I should just mention one word which comes up a lot: normative. Normative is basically concerning the way things should or ought to be rather than as they simply are. But once you're equipped with that, everything else in the talk is going to be both crystal clear, very interesting, very informative, and very should provoke a lot of debate and discussion. We're here to talk for about 45 minutes, and then we'll have the discussion afterwards. Thank you.
Hello, everyone. I'm Joseph Chan. Brian Wong and I am going to do a presentation on the topic treating legal transgressions as a response to state injustice towards a retributivist approach. First, but I'd like to thank Julie and Virginie for inviting us to this lecture series. And we're going to talk about this subject for about 30 minutes to at most 40 minutes. And then we'll welcome questions and answers. Now, in the last 2 years, we have seen many large-scale political protests in different parts of the world. For example, we've seen the Black Lives Matters in the US, the Yellow Vests movement in France, the Umbrella movement and the water movements in Hong Kong. We have also seen protests in Belarus and in Thailand and in some other places. Now, these protests didn't aim at revolutionary regime change as such, but have a limited goal of changing an unjust policy or reforming a flawed institution. Now, although many of these protests were largely peaceful and civil, sometimes they did turn violent. But even so, the participants, in our view, involving in those violence were largely unarmed. So we were talking about, minor violences of this kind and other kinds. So now we can see a lot of, protests. Just to give you some graphic representation, Yellow Vests, the Extinction Rebellion, and as I said, some of the protests involved violence. Now, the literature on political disobedience focuses mainly on what the individual participants may or may not do from a moral point of view or from a legal point of view. Our presentation today, however, focuses on what the state should do with regard to those who have violated the law and got arrested. Hence our topic today, towards a non-retributivist approach. Our focus is that the state shouldn't use a retribution approach to handling legal transgressions as a response to state injustice. Now, we want to develop a comprehensive approach that covers what the state should do with regard to arrest, prosecution, sentencing, imprisonment, and post-imprisonment. Now, before we go to the approach, let's talk a little bit about the parameters, what we do focus on and what we don't focus on, and also some definitional matter. Now, our approach is more relevant to protest in liberal democratic regimes than in authoritarian ones. So our focus is really on liberal democratic regimes rather than authoritarian ones. We think that liberal democratic regimes sometimes do admit that they made serious mistakes. And a liberal democratic state understands that its legitimacy is partially, at least, based on the people's willing acceptance or endorsement. The liberal democratic state may also understand that a mass political protest of a prolonged period of time may signal a kind of government's failure that might eventually undermine its moral standing or legitimacy in the eyes of the public. And finally, a democratic liberal state understands that the rule of law must go with the respect for human rights and civil liberties. And so the state would have incentives to prefer political reform to repression by law as a response to illegal protest. Now, all of these considerations, we think, do not seem to apply to authoritarian regimes, because authoritarian regimes typically refuse to admit state injustice. They also refuse to grant moral permissibility of illegal protest. They rather preferred, repression and rule by law rather than rule of law. So authoritarian regimes, we guess, have little incentives to consider a reconciliatory approach such as the one that we are now advocating here. Now, let's talk a little bit about the notion of disobedience. We confine treatment of legal transgressions to what we call conscientious disobedience, and which includes both civil and uncivil forms of disobedience. Now, disobedience is understood to be a violation of law, often resulting in disruption to law and order. And disobedience is conscientious if it is motivated by what the disobedient perceives to be state injustice. State injustices, for example, include the state's direct violation of people's rights or freedoms, such as racial injustice, police brutality, or political disenfranchisement, as well as indirect injustice, such as the state's mere failure to rectify long-term social injustice. So here I've laid down the parameters and the definition, and we now move on to the main normative argument we want to put forward. And now I'm handing it to.
Thank you very much, Joseph. So this is effectively our normative argument. And to start off with, I want to just clarify what exactly we're trying to offer here today with our argument. There are broadly four premises at hand. The first is the view that there's something normatively distinct between conscientious disobedience and non-conscientious disobedient transgressors of the law. The second premise is that the state ought to take this distinction seriously. The third, and this is where we engage with some of the existing literature, C.F. Lefkowitz and Kimberly Brownlee, we argue that such a distinction cannot be cashed out through Lefkowitz's punishment and penalty cut, but nor should it be discharged or manifested through Brownlee's argument, which we'll touch upon in just a second. And the final premise is that the best means of cashing out this distinction is via our new jointly proposed sliding model, or sliding scale model, rather. So let's move on to the first question then. Broadly speaking, what, if at all, is distinctive about conscientious disobedience? Now, the following constitutes reasons for which we may deem individuals who perpetrate conscientious disobedience as normatively distinct from those who commit crimes or break the law for reasons that are unrelated. So in other words, I think the focus that we want to sort of touch upon here is distinctly agential. It's about what's different, between agents that we're looking at here and agents that fall outside the scope, perhaps, of our model. We seek not to offer a general phenomenology of why conscientious disobedience is innately different. We only seek to make a more modest claim that the characters of the agents here should be judged differently, at the very least within the moral sphere. And there are three possible explanations, the strength of which and the comparative preference amongst which we are ambivalent, so we're open to all three suggestions. The first explanation concerns the intention and the motivation of the agent, where conscientious disobedience effectively seek to achieve social-political changes, whether it be in reforming unjust structures, in achieving compensation or rectification of past wrongs, or just in protesting unjust laws to some extent, via means that may or may not be civil. Yet the ultimate fulcrum of the act here is not in and of itself ulteriorly motivated or propelled by self-interest. And this therefore means that we can juxtapose this against, say, a theft, a burglary, or someone who engages in an acquisitive crime to enrich their own pockets. So I think that's the first distinction that indeed Dworkin touches upon in his extensive analysis of civil disobedience, and we won't, elaborate on that too much. The second explanation is that these individuals are performing such acts as a last resort, or alternatively, as a quasi-last resort. And why the quasi here? Well, the reason for this expansion of the scope of what we deem to be permissible sources or stems from our belief that the criterion of last resort historically in the literature is both excessively demanding upon individuals in real-life constraints and circumstances, and fundamentally unresponsive or not sufficiently cognizant of the circumstances of activism, where very often it's hard to adjudicate subjectively when not the last resort, or this is indeed the only resort and the last resort through which change could come about. The final justification revolves around the communicative benefits attached to the public act of disobedience, and in particular conscientious disobedience, which comes along with it often an expression or an articulation of what's wrong and what's at stake here, but also an attempt to inform the public. And a lot of the existing literature on civil disobedience seems to potentially neglect this aspect of civil disobedience as a speech act. Whereas if we look at, say, certain segments of the deliberation literature, we've seen from, say, Arshan Fong, but also Ackerman and Fishkin, frames that characterize civil disobedience as acts and means of achieving and facilitating better discourse. We don't want to go into too much detail here, Joseph and I, concerning the intricacies of these claims, but the bottom line and the upshot here is, at the very least, civil disobedience is robustly justified to the extent it is permissible by the existing literature, and we therefore assume for the rest of the argument that we can indeed take civil disobedience, at the very least, as conditionally permissible. But of course, a question may arise here, that whilst the above justifies, to some extent, civil disobedience, it's not clear why these reasons uniquely justify uncivil disobedience, i.e. the other part or the other half of conscientious disobedience, where force is deployed, where conditional deployment of violence may indeed occur. So the worry here is that the above reasons offered are inadequate in grounding our thesis and framework. So we offer a few suggestions here as to why fundamentally we should extend the above to also non-civil disobedience. The first is the view that we should stretch our understanding of what is proportionate in cases where there's structural violence or egregious violations that persist and proliferate throughout society. The underlying claim here is, to the extent that proportionality is an important doctrine, we should be perhaps a tad more cognizant of what violence, or what forms violence by the state and engendered by the state could take. That instead of just viewing the status quo dichotomy as between either civil disobedience or other forms of totalistic radical action, a bifurcated model, in other words, of interpreting the phenomenology of activism. Perhaps what we need here is just a more central or middle ground approach to making sense of minimal or low intensity violence and seeing it through the lenses of structural violence and as a proportionate response to transgressions upon the people's rights and liberties there. The second reason, though, is that there's a genuine lack of closely accessible alternatives. Now, of course, in democracies, liberal democracies that we're focusing on here, there's always the non-trivial chance that folks could achieve the political changes they want to see through other means, through elections, through votes of no confidence, of course, through judicial review, through other sort of invocation of established public institutions and all that. But what we're arguing here is that we shouldn't apply the stringent criterion that there are no alternatives as a test, simply because this ignores the fact that there might be alternatives that are trivially possible, but these trivially possible alternatives are by no means normatively relevant or salient to the actor, to the agent on the ground who is unable to access these structures and also the power of these institutions. And that's why, in order to take the no alternatives condition seriously, we should be open-minded to conscientious disobedience, i.e. a more, robust form or strengthened form, a more expansive conception of disobedience rather than just civil disobedience. Finally, and this is just a thought that we have and would be very much open to discussing subsequently, of course, we assume that there's some normative permissibility of non-civil disobedience under certain circumstances simply because, fundamentally, the cut or the dichotomy between civil and uncivil, violent and non-violent, is practically untenable under actual circumstances. So the case in point I want to raise here concerns police brutality in the US. Trayvon Martin, or indeed earlier this year, the protests that erupted over the killing that erupted over effectively excess police force, without going into specifics there. Now, obviously, we could say that the protesters could have adopted more peaceful means. It might have been consequentially and utilitarianistically justified. But we should also be cognizant of the fact that adjudication of real-life circumstances in politics isn't as simple as what we can proffer from within a relatively secluded and privileged discursive space. So with that said, let's move on to the next question. Now that we've established that there's something distinctive about this form of disobedience, we then ask, why should the government or the state take seriously this difference, if at all? Perhaps the moral and legal ought to indeed be kept apart from one another, right? And perhaps we shouldn't move from the above normative observations to legalistic or quasi-legal prescriptions because they remain separate spheres of justice and whatnot. Well, we think this view is misguided. That is, the attempt to keep the two spheres entirely separate from one another is misguided for broadly speaking, two reasons, really. The first reason is that the state's right to punish, Pache Zin 2002, is correlated with its specific legitimacy and moral standing vis-a-vis individual citizens. If the state persistently violated the interests of the citizens and flagrantly disregarded the protests, the objections and the challenges, we do not think the state has a right to fully punish or to pursue the retributive penalties that have been touted by certain circles or certain folks as a solution to such social unrest or instability, simply because there's undermining of the fundamental promises and also the implicit contract that the state has made, or the compact that the state has made with the citizens. Without relitigating the social contract arguments there, the broad thoughts that we have is fundamentally states should be reflective upon the moral constraints and also moral imperfections that it has, and channel that understanding into its penalty and punishment-centered decisions. The second part of the equation, though, is about the judges and prosecutors who, one may very correctly observe, are not necessarily complicit or participants in the violence and the injustices that we talked about at large. So what duties do they have? Well, in their cases, or in that case, we'd posit that these judges and prosecutors should still recognise the normative differences in terms of the characters and moralities and also the mindsets of those that are being prosecuted for several sub-reasons. The first sub-reason concerns equality of will, that between an individual, so ceteris paribus, between an individual A who commits a crime out of, broadly speaking, only self-interest and also with flagrant recognition that it is immoral, versus B, who commits the same act, perhaps, with a very different intentionality, though, and also ensuing sort of responses to the act. Presumably, judges should take this difference between A and B into account in parceling out different sentences for them, because that is something that they are fundamentally obliged to do, both within the judiciary system and also in accordance with established norms, and finally, in accordance with the role-specific obligations and responsibilities. But a second sort of intuition pump, I suppose, or argument would make is when it comes to culpability, where if someone's sentenced or not, obviously the decision concerning if someone's committed a crime should be reflective upon the actus reus and what exactly is at stake, as well as the mens rea. With that said, we can still accept that two individuals can be convicted of the same crime, manslaughter or murder, without therefore accepting that they ought to be given the same punishment. And this is something that we see already in existing jurisdictions, where judges can exercise discretion on the basis of mitigating circumstances, but also other factors they can factor into consideration at large. So, with all that said, and finally the prudential reasons as well, but I will leave that to a latter part or later part of our presentation, the end conclusion of this question is that the state should take this difference seriously, and it does indeed matter. Now, segueing into the theoretical debate today, let's take a very brief segue, and I think this is quite important in charting the theoretical landscape. And a question that we'd like to ask is there a case for penalty without punishment, i.e. a model that has been touted and raised in recent literature? Well, Lefkowitz argues that we should adopt a balancing model, a model through which he wants to reconcile two seemingly contradictory, but fundamentally, according to him, complementary forces. The first force concerns the instrumental prudential reasons in favour of imposing sanctions and costs in relation to legal transgressions. And this is justified on the basis of reasons of public utility, stability, and finally, just upholding law and order at large here. The second prong, though, concerns the fact that individuals do have the right to political participation, he argues, and that such rights should extend to warranting the rights to protest and to break the law when formal institutions are systemically incapable of accounting for or incorporating their wills. The argument he then offers is, in a case of civil disobedience, the state should still penalise civil disobedience because it's literally breaking the law, or it's an act that breaks the law, but it oughtn't punish it. And when it comes to not punishing it, to cash out the content there, he reckons the state should actively emphasise and also carry out actions that commensurate with the stance that these individuals have not acted in an immoral manner. That whilst they've broken the law and there's a political obligation and there's a political duty to prosecute them, they should not be punished in a way that stigmatises or demonises their methodology. Brownlee makes an objection here, and Brownlee argues that Lefkowitz's argument doesn't go far enough, and that presumably justifying penalty and the exercising of fines and all of these other remedies also requires non-prudential and non-instrumentalist reasoning to back it up as well. That simply invoking the argument that this leads to better consequences doesn't necessarily make the argument justified, and if anything, it reflects sort of a misjudgment of how states and citizens ought to interact. And that's a fair criticism, and that's a very potent objection. But on top of that, Joseph and I would also like to lodge a separate challenge to Lefkowitz's cut, because presumably, when it comes to instrumentalist considerations and the case for punishment, for penalty rather, to accept the instrumentalist justification for penalty should also require us to accept punishment, given that it is precisely the communicative and symbolic effects of punishment, as opposed to just mere penalties, that serve arguably the most important deterrent function for prospective criminals. So if you can't communicate the illegality and immorality of an act, then you're massively undercutting deterrence and also other forward-looking considerations that Lefkowitz talks about there. So in short, we've surveyed the literature in this particular debate and felt that Lefkowitz's argument doesn't necessarily provide the solution that we need, despite the admirable attempt. So what of Brownlee's alternative proposition then? Well, Brownlee offers an alternative model where, instead of thinking of it as an ambitious cut between punishment and penalty, she thinks there's a potential consideration on the part of the state to not punish the individual. With that said, it is a very potential consideration that she emphasises can be outweighed by other considerations. And when they are indeed outweighed by other considerations, the state should apologise to the individual when punishing them. This is an interesting amendment, but Joseph and I have two further worries concerning this move. The first is we feel that this fundamentally is a bit of a cop-out, that by transforming this case for not punishing the individual into a pro-tenal consideration, this move also kicks the can down the road, right? It's very easy for us to say, look, there's a pro-tenal consideration in favour of punishment, of non-punishment. It's not clear how strong, how potent, how important, urgent this pro-tenal move is. And the second question that we have is, what exactly is the point of apologising when the state is the primary agent who's executing and enacting the punishment? Surely a more cogent account would be one where apology or no apology, that is the question over that, is folded into the decision to or to not punish, or into the miscellaneous but important additional measures that the state ought to take. As opposed to just apologising, the state might have to compensate these individuals who partake in conscientious disobedience, or they might and should offer additional support. And indeed, that is a direction that our argument and eventual strategy would take. So with that said, let's turn on to, finally, our new sliding scale model, premise 4. Our new sliding scale model fundamentally argues that punishment and penalty can't be separated both in practice and also in theory. More importantly, though, if we think about or treat this system as a sliding scale, on one hand, or on one end, you can have full punishment and penalty on one end, and on the other end, you would have neither punishment nor penalty. So rather than thinking of them as disparate categories, we see them as working hand in hand, but they are, of course, variables and reasons and factors we need to consider in order to decide how severely these individuals who partake in disobedience are punished or penalised, if at all. And what are these possible reasons? When it comes to forward-looking reasons, we're talking about, fundamentally, would this impact the state-citizen relationship? How well does the model, if at all, rehabilitate those at hand here? Will this cause further resentment and instability? Does this undermine the compliance with the law at large? These are all variables in a non-exhaustive list of variables that could matter there. On the other hand, there might also be backwards-looking reasons that are quite important. Were there indeed reasonable alternatives that these folks, these disobedience, could have adopted? What were the states of mind? What did they intend to do? Were the damages and harms they enacted proportionate to the things that they were protesting and seeking to transform? And through that, we arrive at, in each case or in each particular instance, case-specific rulings and case-specific judgments. So instead of a blanket policy or a blanket argument that universalistically argues that we should accept at all times, or across all times in instances, disobedience, Joseph and I would posit that a more contextually tailored and particularist understanding of justifiability of disobedience would be helpful towards a more justified legal response as a whole. So with that, I now turn my time or pass my time over to Joseph, who would explain our proposal and our advocacy.
Right, thanks. Right. Now I think it's time to explain our general approach to handling legal transgressions. But first, let us highlight some of these main features. The first point to note is that it is a policy framework adopted by the government, or better still, it is a piece of legislation debated in the society and passed in the legislature, so that the whole framework has a political mandate, so to speak. So it's legitimized, as it were, by an elected democratic government or an elected legislature. The second point is that it is a systematic approach that covers all stages of a legal or judicial process, from arrest, prosecution, sentencing, to imprisonment and post-imprisonment. The third point to note is that I think one strong advantage of this approach is that it will take away the heat from the courtroom, as it were, in the sense that judges do not need to make judicial decisions based on their own controversial political or moral beliefs. Rather, we have set up a framework within which all legal professionals have to follow. Now, according to our approach, the discretion is to be given to mostly the prosecutors, although they're expected to follow the policy framework, as I said. the prosecutors are the one to initiate prosecution using the policy framework. And so we want to sort of suggest that the adoption and implementation of this framework is not a purely legalistic process, but a primarily political and moral one. Now, let me talk about what kind of offenders who will be eligible to be placed under this general framework. Now, a protest, as we understand it, is a response to perceived state injustice. So first of all, the protesters or the offenders have to believe that there are state injustices out there, and they participate in the protest with the aim of changing a certain policy or reforming a certain institution, at least publicly expressing serious discontents. Now, the second point is what the offender did was really, what the offender did had to have a rational connection with the aim of the protest. That is to say, the offender was not using the protest as an excuse to do something else that is unrelated to the protest aim. For example, looting, generally not rationally connected with the political aim of the protest. So we only want to include offenders of this kind who are genuinely motivated by the perceived state injustice and rationally connected to the pursuit of a political goal. Now, finally, we only want to include offenders whose response during the protest would be roughly proportionate to the injustice or the threat imposed by the police during the protest. And this brings to the next slide about the criteria of application. In our view, because Brian talked about a sliding scale, and we prefer a sliding scale rather than a either or kind of framework to punish or to penalize or not. So we want to distinguish three kinds of case. The first kind is a black case, that is, cases in which the offenders are not eligible for this framework. As I said, these offenders are offenders whose responses are disproportionate to the scale of injustice or to the threat from the police or other people during the protest. For example, if a protester actually committed killing a cop or seriously injured a cop or an ordinary citizen during the protest, that's probably a disproportionate response, assuming there was no life-threatening kind of attack from the other side. But we consider that in many protests, there are white cases that are clearly eligible for this framework, for the use of this framework. For example, if an offender simply committed so-called an offense of unlawful assembly or unlawful demonstration, or committed an offense in the obstruction of road traffic, or some kind of minor violence or vandalism, then we deem these cases to be white cases, meaning that the prosecutor could put these cases under this general framework. And of course, there's a third kind of cases where the nature is gray, is a bit controversial, borderline. Some kind of violence which is not very minor, but not as life-threatening as killing, like break an arm, or give a strong kick to a cop, or throw a petrol bomb, not to a person, but in between the police officers and you, so that you get more time to run away. Now, these are the gray areas, and we will suggest that we will let the prosecutors to decide on a case-by-case basis. So this is the general framework about the eligibility of offenders and the different kinds of cases. Now let's move on to the role of the police. And now, during a, for example, merely unlawful assembly that doesn't involve any violent action, perhaps what the police should do is to tolerate such unlawful assembly, to let people express their political discontent. And if necessary, the police would be to disperse them rather than to arrest those who participate in unlawful assembly. But if protesters are to be arrested, after they are arrested, the police would have to do investigation, and they would have to decide which options to take. First, the option of what we call diversion. A diversion option means not prosecution, but put the offender or put the case in an alternative scheme, such as a mere warning by a police superintendent. In Hong Kong, we call this the police superintendent's discretion scheme. It is only limited to young offenders under age, but in our proposal, we want to lift the age limit to include everyone. Another alternative scheme would be a buying over, which is not a conviction nor a punishment, but an agreement of the offender to engage in good behavior within a certain period of time. And whatever the alternative scheme, the government may consider giving counseling services to the offenders during the police investigation period or after. So these are things that the police could do. Now, what about the courts? And first, we talk about prosecution. Prosecutors are the ones to decide whether to put the case under the scheme. And if under the scheme, then those of the later recommendations of this framework will apply. If they decided not to place it under the scheme, that means the offendant will be treated as a normal kind of offendant and to be convicted using the normal legal procedures and standards. If a defendant is not put under the scheme and then convicted, we will suggest that the convicted defendant may still have an opportunity to plead to the court to place his own case under the scheme, so as to give him a second chance, as it were, to defend the genuine motivation of him and to debate about the nature of his crime. Okay, so after prosecution, then the judge will decide, and if the judge decides against the defendant, that is, the defendant is guilty of the charge, then what follows is a sentencing. Now, we would recommend that, first of all, the court should consider some kind of lenient sentencing arrangements, such as compulsory social service or rehabilitative sentences, as opposed to imprisonment. But even if imprisonment is the sort of a decision made by the judge, then we would recommend a lighter sentencing than similar crimes falling outside of the scheme. Now, of course, the sentencing has to depend on the circumstances of the offense and the quality of will, as Brian alluded to, and also other possible mitigation factors. Now, once an imprisonment decision is made, then the offender will be sent to prison. Now, we would recommend that for these people, the prison should offer these offenders enhanced educational opportunities and services. A lot of these people in the protests are actually well educated, and they are young. They have a good career prospect. And so, and they just committed a crime out of their political conviction. And if the state decided that these people should be punished and sent to prison, we hope that the state, in this framework, the state would offer them some sort of supportive services and opportunities, especially with regard to their educational needs of the young people. We also like the prison to offer diverse work opportunities for inmates. And finally, after imprisonment, let's talk about post-release treatment. We think this is a very important point to consider because some protesters would not actually feel that terrible to be in prison for half a year or a year or two, but they would be much more concerned about what happens afterwards. Now, in most legal jurisdictions, if an inmate, finishes his term, and they still face consequences outside of the prison. Now, we want to recommend certain changes to make their lives much more easy. First, we want to suggest, for any imprisonment under 2 years, there shouldn't be any criminal record attached to the offendant. So there shouldn't be any record of their crime. And for those imprisonment that takes the year from 3 to 5, then we would suggest that that criminal record be deleted after 3 years of absence of offense after release. And we would also suggest that there should be some legal protections with regard to the non-disclosure of criminal records. I mean, they are not legally obligated to provide or disclose their criminal records to potential employers. And we also like to think that the state should enact anti-discrimination protections for this group of offenders, and such as that they should not be discriminated against in employment, in participation in elections, to elect or to be elected during an election, or to sit on a company's board of directors. Finally, even more positive measure to adopt is, we prepare or we kind of set aside certain political representation opportunities for this group of inmates. They would be encouraged to participate in boards, to sit on boards, committees as representatives, or on panels and committees concerning prison governance, because they have the experience and they are citizens genuinely well motivated by their understanding of citizenship and their political commitment to liberal democracy. So these are the kind of general details of our framework. And lastly, you may ask, why should a liberal democratic state be interested at all in considering our pretty demanding approach and framework? And Brian now is going to come to this point.
Thank you very much, Joseph. And now, last but not least, I'd like to touch upon some of the prudential reasons and justifications as to why liberal democratic states have the incentives to pursue this particular framework that we're talking about here. So, there are broadly speaking 3 main reasons why. The first is that this framework is the best way of acknowledging both the content and validity of the dissent and disillusionment of the people, and to incorporate the recommendations and advocacy into policy transformations, into changes that render the society able to cater to a larger demographic than the one previously served by the existing order. That seems to be, both on utilitarian and also justification grounds, a pretty good idea for the government at large, especially in ameliorating the legitimacy crisis and improving public optics. Secondly, in expressing its goodwill and openness towards reconciliation. Reconciliation, as we've seen from countries ranging from South Africa to Rwanda, is a primary task for really post-conflict societies, both in terms of getting the economy off the ground and also in minimizing tensions and radicalization and alienation at large. And that ties me on to the final imperative, to minimize the feeling of disillusionment and disaffect in relation to the law. And as Catherine Liu pointed out quite correctly, when thinking about correctional or rectificatory justice, it's not just justice that matters here, but also reconciliation and the purging of alienation that governments have every incentive to consider. So, last but not least, we want to close off with some objections, or rather potential objections. But because we know that we've probably taken up too much time, hopefully what we can do here is just to insert and inject some of these ideas into conversation and we'd very much welcome any and all questions, along these lines in the subsequent discussion that Joseph and I would be participating in. The first is a worry that we might undermine deterrence. The second is that this might compromise as a policy framework our justice and obligations towards the victims. And that finally, there might also be false positives or bullets that we have to bite when it comes to, say, the anti-lockdown protesters and anti-vax civil, or rather, anti-vax conscientious disobedience. Can our policy framework make sense of these instances of protest without being either too permissive or too stringent and also parochial in our judgments? Well, these are questions that Joseph and I would very much welcome your input and thoughts on as well. And with that in mind, we'd like to hereby conclude with reviewing what we've brought forth today. Hopefully, what we've done is to show that there's a new policy that's theoretically and also prudentially justified when it comes to the pursuit of justice in case of state-engendered transgressions or violations of public's rights. That shifts and moves the conversation beyond mere civil disobedience, but also enables us to consider and contemplate reconciliation as a question and imperative at large. The ability on a part of governments to pursue this particular course or to pursue this particular course of action is fundamentally a very important imperative that we think all states ought to consider and should consider, especially in a liberal democratic setting. And with that said, thank you all very much for listening in, and we hope to hear from you, well, now really. Thank you.
Thank you.
Thanks very much, Brian and Joseph. Really a lot to chew over there. We've got some great questions coming in already, so please do keep them coming. So try and keep them within the single 200 character count if possible, and make them as clear as possible so we understand your question. It's nothing more frustrating than asking a question and then finding that we've understood it in the wrong way. Before we come to them, a few points I'd like to ask myself. I mean, first of all, this is clearly a framework that you're proposing for liberal democracies, right? So, I mean, this isn't something you could expect a state which is already, say, totalitarian to adopt. And I suppose that gives some limitations. But I wonder whether some of the things you're talking about help us to rethink what might be going on in any country, sort of authoritarian or liberal democratic. I think what's particularly interesting is the concept you've got of conscientious disobedience. And conscientious disobedience, you're saying, can be both civil and uncivil, right? And I think a lot of the time we're used to thinking about civil disobedience, and that's, in the literature, is the thing which perhaps gets the most attention. And I think one of the most interesting things about the talk was the way in which you problematize this distinction between civil and uncivil disobedience, that there are times where people are, throwing things, using means which might seem quite extreme. And there might be some kind of, a lot of times we try and draw a strict line between those two things, particularly in liberal democracies. But I wonder if you could say a little bit more about that, because isn't it quite important? I mean, most distinctions have fuzzy borderlines, right? So the mere existence of a fuzzy borderline isn't a reason to throw out the distinction. Isn't it quite important in a liberal democracy to kind of be able to say that certain forms of disobedience, those that involve violence and so forth, are simply unacceptable and shouldn't be treated differently from any other kind of criminal behaviour? I don't know which of you would like to come back on that.
Brian, maybe you want to go ahead.
Okay. So I think just a few thoughts, really. The first is, I think, Julian, you're absolutely right that just because the line is fuzzy does not necessarily render that, a defunct or a trivial line. It could still be very important. And there are lots of arguments as to why violence violates site constraints and obviously constitutes a transgression upon law and order. But if I may, just within the liberal democratic context, I'll make two observations. And the first is, we look at the logic and rationale grounding sort of civil and non-violent disobedience. In many cases, it invokes a lack of other options and also lack of availabilities or just proximity of these other options, which ground, therefore, the deployment of force, or ground the deployment of lawbreaking, but not necessarily force in achieving one's ends. And our question simply is, why can't we cantilever upon that, in that if there are indeed instances where A, the harm you experience is so gross and egregious, and B, there truly are no alternatives, and C, that the liberal democratic state requires and regularly sort of involves you in the political process, but even then, you clearly don't have the ability in a non-trivial subset of cases to vote these candidates out, to vote in for changes, then when all of these conditions are satisfied, we wouldn't necessarily say that's sufficient to justify violence. And of course, violence justification is an all things considered concept. But at the very least, we might think that some degree of moderate or limited force might be permissible as an extension of, or in light of everything we've said there. So the line is important for prudential reasons, and obviously the other reasons want to uphold a norm of peace and civility. But again, what we're saying here, advancing here, is merely a pro tanto duty, as opposed to all things considered insistent right or insistent duty in that sense.
Thanks very much. That's very helpful.
Just supplement what Brian has just said. 2 points. One is that if we confine the justifiability of protest to only civil and completely excluding anything that involves a bit of violence, a bit of, pretty extreme actions, then the result would be that, there are very few cases of protest, today, that are just purely civil without having any involvement of things that, like throwing rocks or burning the tire of a car or something like that. So that would make the framework pure, but very hardly applicable to the real world of protest. The second point is that liberal democracy, yes, there are options, there are procedures, there are protections of all kinds, but existing liberal democracies, none of them are perfect. And at times they may fall pretty far short of what we regard as a legitimate, a fully functioning democratic government. Some governments may have committed serious injustice over time, but without bringing down its legitimacy to a totally unacceptable level so that we would call the regime no longer liberal democratic, but authoritarian. They are still liberal democratic, but they are legitimacy deficit regimes. And for that matter, I think there should be more room and understanding of stronger reaction from the citizens, reaction including not so civil kind. Thank you.
Thanks very much. In fact, there's a comment from a Facebook watcher, actually. I had a problem with the Facebook feed. I hope that's back. The question here was a comment, really, that totalitarian regimes, even when protesters do not use violence, these regimes push the protesters to be violent in order to declare the state of emergency. So that they're talking about this. Now, I think this comment's interesting because it relates to something I was going to ask you about there, because I think that even the proposals you're making are really about liberal democracies, but people living in democracy, the international community, looking at civil disobedience and protest in other countries, I'm wondering sometimes whether or not there is perhaps a tendency to, we want the protests to kind of be nice and neat. Ideally, we want them to be Gandhi-like. That if you do it in that completely peaceful way, then you get support. As soon as people start to see violence, they get uncomfortable with it. And I'm wondering whether the idea of conscientious disobedience, which may be uncivil, is an important one in getting public opinion and political opinion in liberal democracies to, as it were, reframe and understand a bit differently what's going on where there is real oppression. Do either of you have any thoughts about that? It's a bit tricky.
That's one of the things that this concept could help with, instead of just keep using the word civil and therefore rejecting as a matter of principle any uncivil form of disobedience. And conscientious disobedience could cover both, and liberal democratic states or politicians might feel less bounded by their narrow concept to evaluate what has happened or what is happening in authoritarian regimes. And secondly, although I can understand why politicians in liberal democracy still generally want to refrain themselves from publicly endorsing violence actions, even in authoritarian regimes, because they fear that they may backfire their own in their own country. People would rise up and use violence too. But generally, although they refrain from publicly endorsing it, but they would not go out as strongly as we have seen. That they will publicly condemn violence. So they would still support a demonstration, sometimes separating the uncivil section or population of the protest from the more civil, and they will be more embracing of the civil section of the demonstration, but without publicly cursing or condemning the uncivil section.
Yeah, thanks very much. Did you want to come in, Brian?
Yeah, just very quickly, I think I just want to add on to what Joseph said in that, in terms of the consequences or the consequentialist dimension of the usage of violence, I think it's important that we recognize that the usage of violence often is, in some cases, counterproductive, or it could be futile, or it could lead to public opinion setback. But it's equally important to bear in mind, therefore, that when evaluating sort of uncivil disobedience, we can splinter or should disaggregate the question into A, permissibility, and B, all things considered, justifiability. Because it might be the case that public opinion in both developed and developing sort of countries, or in authoritarian and democratic states, are adversely affected, right? That the sympathies and reception towards the cause are set back by the usage of violence. And that's also a consideration that activists and also politicians and also those sympathetic to the movement should bear in mind, especially when it touches upon, and I've seen this in the YouTube comments as well, the interests of third parties or individuals who might be embroiled in the violence and the fracas as collateral damage there, that their interests should also be weighed in and considered. Yeah.
One fact I just want to add to this is that in some of the philosophical justifications of civil disobedience, I think including Rawls's, make a point that it should be, there's a sense in which it has to be not clandestine. It has to be public, and that's kind of part of the purpose of it. And do you think that's the case with this sort of uncivil disobedience too? I mean, does that make a difference? In other words, if someone is, defiantly and openly in full view, standing in front of, police, protesting in a way that may seem unfair. Or also, I think in Britain we recently had a piece which was not violent, but a bit of public vandalism, if you like, where a statue of a slave trader was thrown into a river. Does it, when judging whether this counts as conscientious disobedience rather than just crime, is the factor of the willingness of the person perpetrating it to be transparent and to identify themselves? Do you agree that's a critical factor or an important factor or not?
Ryan, you want to take it up?
Yeah. So I think the clandestine or the public-private cut can be interpreted in two ways. One way is to see it as the readiness to accept the costs and repercussions of one's act, and the other is sort of just in general the public justificatory version of the argument. Are you informing public debate or merely stifling it and stifling speech? On the first, very quickly, Joseph and I are ambivalent as to whether or not individuals must necessarily accept the legal or accept any costs in association with their actions. Obviously, the standards, the Rawlsian account would say that you need to accept to some extent or another the consequences in order to render that disobedience legitimate, whereas some others, more radical accounts would posit that doing so would undermine both practical efficacy or be unduly demanding upon individuals who are morally entitled to partake in disobedience. And that's a question I think requires both A, intersubjective debate, and B, us looking at the specific context in which civil disobedience occurs in order to figure out the morality of or the justifiability of. Whereas when it comes to the second cut, i.e. one concerning are you enhancing public debate or stifling speech, actually, that's a fair concern. And I think there is a case to be made that if you are trying to use disobedience deliberately, that it can't be performed anonymously and clandestinely in a way that instills fear as opposed to propagating speech. But from the state's point of view and the ethics and the morality of state actors' response, I'd like to think there's a disconnect there to an extent, right? Because a lot of these questions, whether it be through the Rawlsian lens or otherwise, tend to focus on what the individual agent should do. But I suppose there are instances where we can think that the individual agent has indeed violated, softly, a particular constraint or requirement, whereas a state should still adopt, even in those instances, despite what we said just then, a relatively permissive response or approach in light of forward-looking reasons or other factors that we highlighted under our model. So the short answer is it's a very complicated question, but I guess to an extent it's not the case that it being clandestine would therefore nullify or substantially discount its legitimacy. And even where there is indeed discounted legitimacy, the state should take into consideration other factors as well.
Thanks so much. There's some good discussion and questions coming up, as well as a more frivolous matter of Brian's accent, which intrigued me as well, actually. Some people are suggesting it's Australian, Irish, Scottish. Well, he can comment that if he likes or not later. We'll see. But we have a question from the audience, Daniel Butt here. Perhaps we can bring this up. So the approach refers to perceived state injustices. This is what the question says. So is it sufficient that a lawbreaker believe a law to be unjust? Must this belief be reasonable or meet some threshold of moral acceptability? And I guess the problem here is that if you allow it to be simply a question of if you perceive it to be an injustice, it is an injustice, that seems to be too permissive. I could do anything claiming I'm protesting against a state injustice. But on the other hand, if it's for the state to decide whether there's a state injustice, probably the state is going to conclude there isn't. So how does one identify what counts here as a perceived state injustice for your purposes? Again, don't know which one of you wants to take this.
Joseph, do you want me to? Or yeah, okay.
Yeah, go ahead.
Then what I'll say is, so firstly, this is a very fair point, and indeed this is something that we brought up voluntarily. We volunteered the objection on a slide about the anti-lockdown protests as well, where I suppose some folks, those with more liberal inclinations, might think that the anti-lockdown protests are a demonstration of what happens if our model is too permissive. So the first answer, or the first part of the answer, is to say, obviously, there are reasonableness constraints and there are sort of minimalist but nevertheless important constraints as to what counts for both state injustices and also as factored into consideration by a basket of factors, the appropriate response from the state in response to these protesters or these disobedience adopting such methods. So obviously there are constraints, and I think there are two of them that matter in particular. The first is broad or rough proportionality. So if you're seeking to protest a state's requiring that you don a particular hair color, or maybe that's still quite important, or maybe it's just that based on some state stipulation you can't visit certain places after a particular hour, where that location is non-essential to your daily routine and whatnot. So it's a mild infringement upon your rights at large, but then you think that civil disobedience in the form of, or indeed uncivil disobedience in the form of occupying streets and violent abuse and assailment of folks is a response you want to adopt, then in that case that's clearly disproportionate and unjustified because it violates sort of even the broadest conditions of proportionality and roughshod proportionality. The second observation is there needs to be a rational connection between the injustice and the act that you performed here, right? So if I decide to break some law X in response to some completely irrelevant or sort of unrelated violation in my mind of the state in domains Y and Z, and I'm doing it without even thinking through, the instrumentalist lenses, I just see it as the appropriate response because I dislike the state, then that's also something that we can rule out, again, through the minimalist stipulations. But then, of course, the broader methodological concern is, as Julian pointed out just then, who decides, right? Does the state decide? Do we decide? Do the majority people in the country decide? And these are fair questions that Joseph and I had very elaborate and extended debate over. But if there's one thing that we agreed upon, funnily enough, is we reckon this question is best resolved through an idealized deliberative procedure where folks in the country could openly debate and, of course, reason through almost Scandalonian lenses, I suppose, and argue and debate with one another to decide where the lines are settled. And indeed, this is an intersubjective process and probably an idealized process that's quite devoid of reality or the prospects of implementing in reality in some cases. So we are well aware of that. But I suppose in instances where you can't get such deliberation off the ground, or you can't get such debates, then it is the approximation by those who are endowed with, I guess, fair adjudicative mechanisms, it is those individuals' judgments that we then default to, right? That we judge them as the best approximation of what this idealized deliberation could yield, and then we go from there. But this is an absolutely fair objection. If there's one defense or last-ditch attempt to defend against it, it's to say that it's a problem that applies to a lot of accounts of civil disobedience and also disobedience at large. Even the violent, non-violent cut in most civil disobedience debates doesn't usually suffice in these accounts in pushing back or blocking against these particular objections, simply because they pertain to questions of the good and questions over the right, and these are innately subjective questions to an extent.
But before you come in, perhaps you want to add that, Joseph. Before you do, I just want to flag up another comment here from Flower Dong, one of our regular viewers. Welcome back, Flower, who's making a link with an earlier talk in the series by Thaddeus Metz, who talked a lot about the South African Truth and Reconciliation Committee. And you were talking there about this sort of, you call it ideal process, Brian. But in order for this kind of system to work, do there not have to be some kind of constitutional or procedural mechanisms where societies do have a sort of a how can you say reconciliatory? You need certain institutions which perhaps we don't have at the moment. We have the legislature, we have the executive, and so we have these sort of divisions of government. But in order for this to work, I mean, do some of the actual structures of government and state need to be changed, or for at least for it to be work as well as it perhaps should? Do you want to say anything about that, Joseph?
Well, I think if we have to separate between two things: our assessment of individual protests or individual protesters' behavior, and we don't. I think it's extremely difficult to set up a pretty elaborate process, adjudication or discussion, deliberation to just look at an individual case to see whether the case merits certain lenient reaction or kind of response. But if we look at the general thing about, let's say, after a huge protest is finished, and after a couple of years, the government decided to launch an investigation and then to set up a committee to look at why things had happened in the way they did, and what are the things that they could reform and do better, and then set new standards to assess possible future protests. What kind of injustice is there in our structure, so that we have already a good standing of the whatever social or structural injustice embedded in the society. Then we have a more kind of agreed standard understanding of what we mean by perceived state injustice. So there is one quick answer to this question. But if I may, give another slight different point in response to Daniel Butt's question. Suppose, let's say, we have a pretty relaxed notion of perceived state injustice. That is to say, it's not arbitrary, but we hold a pretty low level of threshold. So, for example, when a person is arrested, we would expect the person to give an account of what kind of state injustice that person had in mind when he or she was protesting against. And could he give a reasonable account, meaning at least based on clearly, correct understanding of the facts? If the action was based on completely faulty understanding, and if there were facts that were readily accessible to everyone, but the protesters didn't really take the care to check it, and therefore arriving at a faulty understanding of state injustice, then that could be a problem falling below the threshold. But if there are no factual sort of misunderstandings, so to speak, if the disagreement is about values or the priority of values, like public health versus individual freedom, then I think we would give more kind of, give more readiness to accept the protesters' own account as a plausible account of perceived state injustice. And then we have the consequence or implication that, we would be able to include a lot of protests in our framework, even though some people might dispute about the genuineness of certain cases, but we will still include them. And people might think that, well, this might not have enough deterrent effect for future protests. People would therefore be more relaxed and more motivated to go on the street and protest because, our framework adopts a very low level of threshold for understanding state injustice. Now, this is a thing that we would like to discuss further if there are questions related to the ability of deterrence given our framework.
I mean, it's just worth stressing, of course, that there are penalties for this kind of uncivil disobedience. It's about a different approach to purely criminal activity, but it's not about saying, oh, well, that's okay. It's not like you get a green card. Yeah. But perhaps we should push this a little bit more about the limits of it, because we have from Agora Arendt someone of the view here. It's one of those cases you say could be a potential post-positive. Agora believes that lockdown measures are damaging and undermining civil liberties, and it clearly would take this to be a case where it would be legitimate to say this was conscientious disobedience to protest against it. But I was thinking another case I thought of, which might perhaps be more tricky, is what if I'm a convinced libertarian who believes the government has no right to taxation? Can't I therefore say it's conscientious disobedience to withhold my tax and to hide from that? So, I mean, first of all, we got perhaps there are two separate questions there in a way. Yeah. I mean, I don't know whether you want to sort of go out on a limb and say how you think your approach should be applied to this difficult case of people who believe lockdown is an infringement of civil liberty. But also, what about, is it not a reductio ad absurdum to say that, in the case of the libertarian, they're clear about the facts, right? It's a question of values and philosophical values, but does that mean that everyone who refuses to pay tax should be treated differently from another kind of criminal if they can offer the libertarian justification rather than they're simply just trying to enrich themselves? Perhaps you can both have a go there. Perhaps Brian first, and we'll come back to Joseph.
I want to offer two responses or two parts of the answer. The first and the second part might come into conflict with one another, but that's intended. So the first part is to say, I'm personally of the view that there are prudential reasons in favor of loosening the criteria as much as is possible. And then the second response is basically a scaling fence that allows us to block, I suppose, extreme or deleterious instances of anti-lockdown protests, and also the libertarian example. So starting with the first part, where basically my view is if we are to take our account and our minimalist sort of set of conditions seriously, it is indeed, and it is in fact a virtue of our account that we would say, yes, if our criteria that we outline are satisfied by anti-lockdown protesters and a libertarian who wants to live in a cabin by the lake, then in those cases, they ought to be allowed to, or at least subjectively it is permissible for them as agents from their point of view to carry out disobedience. And I'll offer a few reasons why I think this is a reasonable, sort of sufficiently justified degree of leniency. The first is just the dangers of being too stringent. That we allow the state, or even just our own relatively thick parochial comprehensive doctrines, dictate what we think is justified and not justified. So we can say, public health always triumphs over individual liberties. Or alternatively, public utility and that kind of liberty is always more important than individual liberty. If we say that, A, we risk sort of being unjustified from the grounds up ourselves, but B, there's also the apparent danger of this securing very little buy-in from those who disagree. And finally, the pushback being, okay, given everything that we've said in this presentation so far, what makes them, or why should they believe in all the stipulated criteria that we're outlining here? And indeed, if we apply this to instances where the majority thinks that X is permissible, but a minority disagrees, whether it be in terms of the suffragists and suffragettes, or indeed the civil rights movement in its earlier days, where a majority of society might have been opposed to certain forms of more radical gestures, we would find the intuitive judgment there that we should indeed err on the side of caution, but the caution, or the cautionary side, being an expansionary one, where rights are embraced and recognized as opposed to shut off. And obviously, in a case of the civil rights protests, you could say, well, maybe the disagreement there is more like over means as opposed to ends, right? So procedural divergences should give rise to tolerance, whereas if it's a substantive disagreement, we shouldn't quite accept that. So if your substantive end is to destroy the roads and set fire to buildings because you oppose lockdown, and we need to say no to that. But even then, I don't find that procedural ends cut or the means ends cut necessarily particularly tenable. So that's why, personally, the first part of my answer is let's err on the side of caution, with the side of caution being expansive as opposed to pro-limitation and restriction. But, and this is where I guess the second half comes in, that just because it might be subjectively rational for these agents to pursue disobedience doesn't mean that it is, all things considered, intersubjectively justified. And what is relevant then in that transitory phase of process is all the whole roster of miscellaneous considerations, whether it be the external harms you might bring about, or the fact that if I were to tolerate and comply with the anti-lockdown protesters' petitions, I might be undermining other individuals' conceptions of what public governance ought to be. And indeed, you see that empirically in America with individuals protesting lockdowns and also protests and counter-protests pertaining to police brutality. So the short answer there is there are loads of extraneous factors and variables that could be relevant depending on the context in blocking out our extension of the model to tax evasion or tax avoidance. And indeed, in the case of not paying taxes, we could think, A, that excess non-paying taxes could be depriving individuals of what they are rightfully entitled to as fellow citizens, or the protections and healthcare and welfare benefits. But B, that once this is indeed performed without any repercussions, the downstream consequences is a lot more. Far more folks would also start refusing to pay taxes to see this as justified on libertarian grounds. And then that obviously undermines core public prudential goods and benefits. And these are external reasons as to why we might oppose both allowing people to not pay taxes and also, in the case of lockdown, allowing the pandemic to spread because, they think lockdowns jeopardize businesses, but actually allowing the pandemic to spread via not having lockdowns could also jeopardize businesses and more lives there. So I guess these are the two chunks and components and moving parts that are, to an extent, tense with one another, but also collectively comprise my thoughts and answers to the question.
Thanks. Joseph, you got anything to add?
I generally, Brian and I discussed this, and what Brian said, is what I would agree. But I'd like to add just two slightly different points. Brian and I said we prefer a kind of a more lenient or permissive approach to cases of protest, whether how serious is the state injustice, how well accounted for or explained of its perception of state injustice. We think such a loose or kind of a undemanding sort of approach is a virtue for two reasons. First, I think normal citizens wouldn't take the risk of participating in collective protest, if not because of their serious discontents. And so therefore, we don't want an approach that is so rigid, that has so high a deterrence effect as to be so prohibitive that citizens would not dare to engage in illegal protest in desperate circumstances. Another point is that adopting this more loose framework will serve as a reminder to governments that actually when they govern, when they make policies or laws, they should do their best to minimize the chance of collective protest by effectively addressing citizens' demands and grievances. So this is actually we want to put the onus on the government to do better, to avoid, or to make sure that not a lot of people would actually feel so unhappy with the situation that they have to, take the task to the street and then engage in highly sort of a controversial or kind of provocative protest.
And that's very interesting, actually. It relates to a question from Sri Agnihotri, which we might be able to get up here. which is talking about whether, really asking the question whether or not what you're suggesting is too statist. Now, this is interesting because you're saying part of the purpose is to put more pressure onto states. And this question, another question as well by Christopher Chaskos, he was saying that he basically believed that governments are never going to accept for themselves that something is illegitimate, and so therefore this only kind of works if you have some kind of, he suggested, limited government sanctioned by constitution. So I guess just to put those thoughts together, the worry is that if the state is going to be basically into too much power to decide what is legitimate and not, in order for this to work, the state has to be deprived of that power somewhat. How do you deprive the state of having the power that would enable it to essentially, decide what it's going to ignore and what it's not going to? This might be a kind of a detaily, nerdy constitutional question, but it's an important one, I think.
So I think Joseph,
Joseph
and I think, Joseph and I broadly think that to some extent or another, the state centrism is a bullet that will have to bite, and of course with that comes the cost of practical impediments and barriers. But if there's any consolation, I think the consolation is to be found in, we think fundamentally the state's incentives to adopt our approach do exist, and a lot of those incentives we covered in the presentation as well, whether it be in terms of initiating reconciliation, mollifying crowds, dissipating or sapping away the capital from the opposition, or fundamentally just enabling a cross-partisan reconciliation in otherwise healthy democracies. A lot of these are valid considerations that may tell for the state being more lenient and permissive, more than indeed, or in a way that we might be surprised by. But it also helps, I guess, in liberal democracies that you have partisan turnover and you have basically parties in power being replaced by those that aren't. So we're thinking perhaps more specifically the Irish, the Ireland UK interaction, and of course Northern Ireland in that case, and troubles there. But in the case of South Africa, whilst you might question or dispute the extent to which it's a functional democracy, again, the extent to which there's been reconciliation in the aftermath of apartheid. And I think a lot of these questions fundamentally turn on how well do those advocates or those who are pushing forward this particular proposal communicate and engage with the government, whether it be a government that's democratic or liberal or authoritarian and whatnot. It's ultimately an actor that's propelled by self-interest. And self-interests are dynamic. It's not a static concept that's rigidly confined within a particular set of ideological predispositions, or rarely do you see that being the case when it comes to healthy and robust democracies. But moreover, when it comes to the worry that we might not be able to guarantee this without constitutional guarantees, that's super fair. And certainly, if there are ways of building in a constitutional clause in favor of TRC or in favor of adopting this particular approach, then that's very plausibly something that could be considered. And I guess another approach to that, though, is to institutionalize a political norm where you could have forms of disobedience that are publicly acknowledged to be illegal and even sort of in violation of these legal doctrines, and yet concurrently are viewed as morally justified and warranted. And if there's a discursive culture or norms that are in favor of that, then presumably you get a more dynamic calibration mechanism where you don't need sort of radical changes to the regime insofar as just regime concessions and regime reforms from within that fundamentally create that space again for concessions and also for a softer approach. But admittedly, our approach is state-centered and presumes that the state continues to exist and function and manifest, including in ways that may or may not conform with ideal theoretical stipulations. But that is also, I guess, a virtue of our proposal and what's different about it vis-a-vis other theories out there.
Yeah, Joseph, you want to say something too?
Can I just add one more point? Instead of saying this is our approach is statist, of course it's statist because we can't get around states. States monopolize violence, as Max Weber said, and they are there to maintain law and order, to punish. So our subject is about punishment and arrest, and so we cannot avoid the state. I think the focus is not so much about the status aspect, rather than our focus is the political aspect, rather than simply a deceptively legal perspective. As I said in the presentation, one of the virtues of our approach is that we try to take heat away from the courtroom, as it were. Even prosecutors do not do anything. Given one of the comment here I saw, are we putting too much pressure on the prosecutor? Well, if we do not rely on the prosecutor, then the kind of expectation and controversy will then be shifted back to the judge themselves. And that is actually bad, because we do not want to politicize the court, as it were. Judges are there to interpret the law and not to implement the law according to their own personal conviction. So instead of politicizing the court, we want to politicize the prosecutors. That is to say, but we don't want to give them too much discretion. They have to operate within the framework enacted by the government or by the legislature. So they have already got some mandates to do what they are expected to do. But nevertheless, it is still clearly a political decision, controversial. If a prosecutor decided to prosecute using this framework or not to use this framework, this is their this is their discretion, and they have to bear political responsibility. Now, this political responsibility will ultimately be transferred, I hope, from the prosecutors to the administration. So people can then evaluate how responsive, how adequate is the current administration in the government, how adequate is their response to the protests and the aftermath and the treatment of legal transgression. So there is one thing, I think we are rightly putting the burden on the administration, including, the Department of Justice, to perform certain political tasks that is optimum according to what we understand a liberal democracy should be doing. A second point is that although the current administration might be reluctant to use this approach to legitimize or to let go, set free some of the protesters who are arrested, or to apply a lenient sentencing, because suppose they don't want to admit of the mistakes, they don't want to say they have made a blunder. But then the next administration might come in. Now, if this administration refuses to use this approach to handle this, then people will be angry, and then let's say this administration will be voted out in the coming election, then the new administration will have more incentive to use this approach to deal with previous unsettled legal cases. And I think that is an advantage. We have seen in other countries like Taiwan, a protest that took place in one administration. It took a long time for the prosecutor to deal with it. And when the prosecution was about to take place, we saw a change of administration. And then, given the change of administration, the Department of Justice would face or would receive new instruction from the administration as to how this kind of protest that took place in the previous administration. So I think this approach will give the flexibility to the fact that administration comes and go, and therefore creating new possibilities and opportunities for reconciliation between the state and society.
Thanks very much indeed. We are kind of coming to the end. We're going to run over very, very slightly, but I did want to give you just a very, very brief word, because at the end of the talk, but then also in the discussions, this issue of deterrence came up. I suggest this is, I get the sense perhaps this is a worry that you have is one of the most serious ones for yourselves, which is the question that if you have this sort of extra leniency, does it not create the risk that it just opens up a Pandora's box where people are going to be too willing to take to extreme measures? So I wondered at the moment, is this something you're still struggling with, or have you come to a conclusion? Are you satisfied that this worry is not something that we should concern us too much. Perhaps just one of you could pick that up as a final brief comment.
Maybe I just quickly make 2 points and then Brian could supplement. I think if, let's say, our approach is not deterring enough, therefore seeing more and more protests coming up from in the country, then I think our approach, but the government could always shift. The government could take the view that, okay, the collective protests that we are seeing are too frequent or too long, so they would decide not to use this more lenient framework to deal with prosecution or future prosecution. So the government has this flexibility and discretion to use this framework or not. And the second point is, I like to quote what Thomas Jefferson has once said. He said that a little rebellion now and then is a good thing, as necessary in the political world as storms in the physical world. So I think protests in a liberal democracy do not necessarily mean something very bad. It is a signal of certain failures on the part of government. And this signal would give important incentive, I hope, to the government to rethink about its policy or its institution, rather than simply, shut their ear up and then pretend things, are just all right, and then use highly repressive measures to deal with the protests. Now, that would be not good for the long-term interests of the country, although short-term it might create some stability, as it were. So that's I want to add, and Brian, maybe you have something, some other points to add.
Yeah, no, I guess, yeah, I just want to close by thanking Julian and also the Royal Institute of Philosophy for the opportunity. But very quickly on deterrence, I don't personally think that decisions over penalties or punishment should feature too heavily considerations pertaining to deterrence, on the grounds that if we are genuinely trying to deter people from breaking any laws, then we should just exact the most draconian of punishments. And that could be a way of solving the issue. So, but then we wouldn't do that even if it were consequentially the best outcome or the best means of doing it. And with that, I think punishment and penalty are more than just deterrence, and arguably deterrence should play a less than significant role in a grand scheme of things as compared with justice and also other considerations. So thank you. And thank you all.
Well, thank you very much. It's actually one of the nice things I like the connections you get between the different talks in the series. And last week, Jesse Norman was talking about mentorship, actually. And I think it's lovely to see a talk where you have a Rhodes Scholar and a senior professor collaborating so well. And as Jesse Norman, as it came out in the discussion last week, this idea of mentorship is not a one-way thing. Clearly, this is a two-way process where both of you getting a lot out of your interaction. It's really lovely to see it in action. It's great you're both here for it. So thank you for that. Thank you for watching. This talk, like all others, is going to be on YouTube to watch for as long as there is a YouTube. Please catch up on any you've missed in the series. Our Philosophers Manifesto has included a number of very interesting propositions, some of which you will agree with, some of which you won't, but all of which will give you something to think about. Please share with your friends, sign up to our mailing lists, etc., because we're going to be taking a break now. And the second part of the series is going to begin again in February. And we've got a very interesting set of speakers lined up there, which we'll be announcing very shortly. Until then, I'd like to say, let's say goodbye to 2020 soon. I think a lot of us like to see the back of it. Thank you for watching, but thank you once again, Joseph Chan, Brian Wong, for a really, truly stimulating and rich talk.
Thank you, Julian, for having us.
Thank you very much.